Good morning. My name is Jesse Furman. I'm a United States District Judge for the Southern District of New York and a proud member of the Judicial Conference Planning Committee that helped to put together this conference. My thanks also to the New York City Bar Association for providing a home for the conference after its unfortunate cancellation in the world we're living in. It is my privilege to moderate the first panel, Lessons of History from the 19th Amendment to the ERA. Before I turn to the panelists and our subject, let me just say a brief thank you to Riva for that extraordinary keynote address to get this important conference started, and it's a perfect segue for our panel in particular. It is a special personal treat to share this virtual stage with Riva. She taught my spouse, Ariella, and me when we were at Yale Law School 20 plus years ago, and she has been an extraordinary mentor and friend to both of us since, and it is hard to imagine a more fitting person to deliver the keynote address on the topic of women in the law and on the occasion of the 100th anniversary of the 19th Amendment than Riva. And that is actually a perfect segue to my all-star panel, because it is a vivid illustration of the mark that Riva has had on scholarship and thought in this area. Indeed, all three of our panelists have worked with and, like me, been mentored by Riva. So let me briefly introduce them. First, we are joined by Julie Sook, who is a professor of sociology, political science, and liberal studies at the Graduate Center of the City University of New York, where she serves as the academic dean overseeing interdisciplinary master's programs. She is also a current visiting professor at Yale Law School, where she is a colleague of Riva's. She has written and spoken widely on comparative constitutional law, anti-discrimination law, and social policy, with a particular emphasis on the ERA and legal issues affecting women. Fittingly for this panel, she is the author most recently of this wonderful book, We the Women, the Unstoppable Mothers of the Equal Rights Amendment, which came out only a few weeks ago. Our second panelist is Serena Mayeri, who is professor of law and history at the University of Pennsylvania Law School, where she teaches and writes about legal history, equality, work, and the family. She is the author of, among other things, the award-winning book, Reasoning from Race, Feminism, Law, and the Civil Rights Revolution. And she is currently at work on another book exploring challenges to the legal primacy of marriage in the United States since 1960. Closer to home for those of us in the Second Circuit, after graduating law school, she served as a law clerk to our own circuit judge, Guido Calabresi. And finally, we are joined by Neil Siegel, no relation to Riva, by the way, or at least that's my understanding, who is the David Eichel Professor of Law and Professor of Political Science at Duke Law School, where he also serves as director of the DC Summer Institute on Law and Policy. He is a leading scholar of constitutional law, constitutional politics, and constitutional theory, and has written widely on constitutional law topics, including, most appropriately for our topic today, a recent essay titled Why the 19th Amendment Matters Today, a Guide for the Centennial. Also closer to home, Neil clerked for the late beloved Circuit Justice Ruth Bader Ginsburg, and indeed he is, I think, coming to us from a hotel room in DC where he has been attending events marking her passing this week. Needless to say, Justice Ginsburg is very much on the minds of all of us today, as the earlier speakers all made clear, indeed as her body lies in state in the United States Capitol, remarkably the first woman to receive that honor in all of American history. One of the tragedies of this conference not going forward as planned in June is that Justice Ginsburg is not able to be here with us today to hear about a subject that was near and dear to her heart and in which she loomed so large. At the same time, it is hard to think of a better way to pay tribute to her and the remarkable life that she led than to talk about women's legal history in the 20th century, because there are few people who played a larger role in that history than Justice Ginsburg herself. With that, let's turn to the subject of our panel, which again is titled Lessons of History from the 19th Amendment to the ERA. It is a perfect year for that topic, not entirely a coincidence. For one thing, as Judge Katzman and Riva noted, we celebrate the 100th anniversary of the 19th Amendment. Indeed, its ratification was just 100 years ago, just a couple of days or weeks ago. And second, earlier this year, Virginia became the 38th state to ratify the Equal Rights Amendment, or ERA, arguably making it the 28th Amendment to the United States Constitution, although that question is in some doubt given the time limit that Congress placed on the amendment. By any objective measure, the 19th Amendment is one of the most consequential amendments in our nation's history. It has been described as the single biggest democratizing event in American history, and for good reason. It led to the enfranchisement of millions of Americans, albeit a promise not fully fulfilled until 1965 with the passage of the Voting Rights Act, and it obviously transformed American politics for all time. At the same time, the 19th Amendment has not figured prominently in American constitutional law. It is rarely cited, and when it is usually in service of a historical rather than substantively constitutional point. The 100th anniversary of the amendment provides a fitting opportunity to reflect on its significance and impact on the ways in which it shaped politics and social movements over the decades that followed, including the drive to enact the ERA, on whether and to what extent it could have or should have played a larger or different role in the development of American constitutional law and notions of sex equality, and on whether and how we still fall short in achieving the goal of sex equality that at least in part animated the drive for the 19th Amendment and the drive for the ERA. Putting aside the legal question of whether the ERA is now an amendment to the Constitution, the anniversary and Virginia's ratification make this an equally appropriate time to reflect on the meaning, significance, and history of the ERA, including whether and to what extent sex discrimination law has effectively done what the ERA was intended to do, and how constitutional law and history might have been different had the ERA been ratified in the 1970s, when Ruth Bader Ginsburg was relying on the 14th Amendment's Equal Protection Clause to create and transform the law of sex equality. These are among the topics that our panelists will be discussing today. Just so you know how we will proceed, we'll begin by hearing from each of our panelists who will talk about these issues and their work and ideas in these areas. After that, I will pose questions to them and hopefully provoke a spirited dialogue among the panelists. During that time, I would encourage members of the audience to use, I think it's the Q&A page or thing on your screen to submit questions. I will try to review them as I am speaking as well and incorporate them into our conversation, and really hope that we have a meaningful dialogue with members of the audience as well. With that, I will turn it over to Professor Sook, to Julie, and thank you very much for joining us.
Thank you so much, Judge Furman, for convening this panel and for including me in this important conversation on this special day. I want to begin by thinking about the legacy of Justice Ruth Bader Ginsburg as a founding mother of the US Constitution. A lot of her work in transforming gender equality in our Constitution was very important and arguably more significant than many of our formal constitutional amendments, even the 19th Amendment. She transformed the Constitution in ways that made sex equality a principle now enforced through the Equal Protection Clause. And the reason this is so important is not only because of the how big the changes were in terms of social transformation, that is, dating back to the demands of suffragists at Seneca Falls and the Declaration of Sentiments in the 19th century. Suffrage advocates had demanded the vote as well as equal legal status in property and family, which is what the ERA came to represent. So the change that we get in making sex equality part of the 14th Amendment is significant because of the social significance of the change, but it's also significant from the standpoint of legitimizing a living constitution, because we have a constitution which is one of the oldest in the world and has many flaws, perhaps due to its age. Barbara Jordan, the first African-American woman elected to Congress from the South, during the Nixon impeachments, gave a famous speech in which she said that we, the people, could include her by amendment and by change, but also that if a constitution today could not stop tyranny by power-abusing men, including perhaps tyranny by men over women, the 18th century Constitution belonged in the 20th century paper shredder. And I would like to suggest that the transformations that were achieved by bringing principles associated with the ERA into the interpretation of the 14th Amendment were extremely significant from this standpoint as well, because they permitted an old constitution to maintain its legitimacy so that we in the 21st century could continue to live under it. So the transformations that are often attributed to RBG's work as a lawyer in the 1970s, beginning with Reed versus Reed in 1971, the first case in which the court struck down sex discrimination, that project was not her project alone, but the articulated goals of women lawmakers in Congress advancing the Equal Rights Amendment, as well as women activists on the streets rallying at the Women's Strike for Equality in 1970, which celebrated the 50th anniversary of the 19th Amendment. And indeed, the quote by Sarah Grimke, the abolitionist from 1837, "All I ask is of our brethren is that they take their feet off our necks." That is a quote that actually appears in congressional hearings by a women's liberation group in 1970 before the Senate Judiciary Committee. And then, of course, RBG quotes that same language in her closing arguments in Frontiero versus Richardson in 1973. That is, the transformations that we're talking about, for which she rightly deserves credit, were transformations that involved the work of many women who came before her and are continued by many women who come after her, including those who have been leading the drive to ratify the ERA in the 21st century. Since RBG was a cultural icon, the comparison to Hamilton, the founding father without a father, is natural. Perhaps we might be tempted to call RBG the founding mother without a mother, in part because of her biography, where she begins her adult life, graduation from high school, just as her own mother dies. And I think this idea is important because she drove constitutional change by standing on the shoulders of mothers who were gone, but who had pitched vision that needed to be synthesized and made real into law. The vision was actually amplified in Congress through proposals for the Equal Rights Amendment. The idea was to enshrine women's equality in the Constitution formally, to eradicate inequalities that women faced because of entrenched gender roles, specifically about motherhood. That is, those entrenched and imposed gender roles were about women being expected to be mothers and nothing else. The vision that came through in Congress in 1970 to 1972 around advocacy for the ERA involved a substantive vision of social change that could not be carried out by the judiciary alone. That is, many of the women in Congress, including Patsy Mink, the first non-white woman elected in 1964, Shirley Chisholm, the first African-American woman elected in 1968, and then Martha Griffiths, the sponsor of the bill, and Ella Grasso, who went on to become the first woman governor of the state of Connecticut. They all articulated a vision that was about needing legislation to make equality real, and the ERA giving political legitimacy to such projects, so that the ERA, once enshrined, would be about a collaboration in some ways between legislatures making equality real through legislation, and only really in the event of legislative default would courts step in. And that vision of the ERA is one that you see articulated in RBG's writings specifically about the ERA in the mid-1970s. And the women who were in Congress advocating for the ERA, Patsy Mink, Martha Griffiths, Shirley Chisholm, and many others, were making this vision real by working on other legislation promoting women's equality, including Title IX, which made educational opportunity real through principles of parity, childcare legislation, a proposal that actually gained quite a bit of bipartisan support, although it was eventually vetoed by Nixon, and a fair credit statute, which would give women access to credit cards, which they didn't necessarily have even at this moment. This vision was not only made by legislators, it was also a movement vision, because the Women's Strike for Equality, the largest women's march of the 20th century, included demands not only for the Equal Rights Amendment and equal opportunity at work, but also for legislation on childcare, because it was understood that unless women had some place to leave their children during the day, a promise of equal opportunity at work or in education might be empty. Ginsburg brought this vision to the Supreme Court in the cases that she argued or briefed, beginning with Reed versus Reed. There she embraced her constitutional mothers, Polly Murray and Dorothy Kenyon, trailblazing women lawyers whose names she included as co-authors on the brief, although they had not explicitly participated in writing that particular brief. This is another example of her standing on the shoulders of these mothers who are absent from the brief but very present in the work that is being done. Polly Murray had testified in ERA hearings during 1970, which became an article on the Negro women's stake in the Equal Rights Amendment, saying that the ERA would be different from equal protection because, more so than equal protection, it addressed the question of equal power and would lead people to think about dangerous power imbalances in Congress, which arguably persists in 2020. Dorothy Kenyon was actually a lawyer who had brought unsuccessfully equal protection cases challenging sex discrimination. And very interestingly, she had opposed the ERA when it was first introduced in the 1920s because she and other social reformers did not trust the sitting federal judiciary to enforce the ERA in a manner that would sufficiently protect the interests of women working in industry. This was the Lochner era, and courts had struck down labor legislation. And in 1923, the Supreme Court struck down women's minimum wages by invoking the 19th Amendment. In Atkins, the Supreme Court said that because the inequality of the sexes was now coming to a vanishing point, as evidenced by the ratification of the 19th Amendment, women no longer needed special labor protections. Kenyon was concerned, and she expressed this in ERA hearings in the 1920s, that the ERA would function like a blind man with a shotgun. You couldn't predict what it would strike down. She was aligned with reformers like Florence Kelley, who had worked on the Brandeis Brief in Muller versus Oregon, which had upheld labor legislation that protected women only. And the Brandeis Brief, of course, is famous for looking specifically at the empirical realities of women working in industry at the time. The ERA was introduced in the same year that Atkins was decided, 1923, by a militant wing of the suffragist movement, the National Woman's Party. They believed that equal citizenship required another constitutional amendment guaranteeing women equal rights in all matters beyond the vote. And they were really targeting laws that were still on the books at the time in many states that limited married women's ownership of their own earnings if they worked outside the home, and married women's legal guardianship over their own children, which was often in question. But the social reformers saw how the Supreme Court struck down women's minimum wages and invoked the 19th Amendment in actually a different way. As they talked about the importance of the 19th Amendment, they suggested, and I quote Florence Kelley, "Have we forgotten that the most important labor law ever passed never mentioned labor? That is the constitutional amendment which gives to working women and to all other women the right to vote. It is by far the most important labor law concerning women that has ever been or ever can be passed. It is the law which gives to half the people of this nation the power to register their will and their conscience." But this led Florence Kelley and Dorothy Kenyon and many supporters of women's rights to oppose the ERA because they thought that the 19th Amendment should lead women to vote for people who would adopt legislation that should then be upheld and applied, legislation that would make equality real for women. And indeed, to the extent that they were interested in new constitutional amendments after the 19th Amendment, they were interested in amendments that would actually empower Congress to pass legislation on things like minimum wages and social legislation in general, and an amendment that would then preserve such legislation in the face of possible judicial attack. So this vision that legislation would be central to making equality real then comes back in the 1970s in the work of the lawmakers who associate the project of the ERA with legislation on child care and Title IX and many other initiatives that would make equality real for women. So in conclusion, I think that we can think about the Reed versus Reed brief by Ruth Bader Ginsburg, which is a tour de force and pieces of which you see in other briefs that she writes throughout the 1970s, which then shaped the Supreme Court's decisions, that this is a synthesis of this history. And of course, even Dorothy Kenyon, who had opposed the ERA in the 20s, by 1970, she had changed her mind. And it's because the ERA and the project of women's equality changed and synthesized this concern of social feminists on the one hand, and the feminists who wanted a more sameness approach through a blanket amendment, getting rid of all sex distinctions. So I want to conclude by suggesting that the transgenerational drive for the ERA shaped the advocacy that then changed how we think of the 14th Amendment. We might say that the Constitution was actually amended without an amendment. And the current ERA revival aspires to formally add the ERA to give legitimacy to the contributions of these women as constitution makers. And to my mind, RBG is a founding mother and is a woman constitution maker. I do think that having a formal amendment that recognizes this work would make it official, that both RBG and all of her foremothers are founding mothers. Thank you.
Thank you very much, Julie, for those wonderful remarks. Next, we'll go to Professor Mayeri and Serena.
Thank you so much, Judge Furman, and I'm honored to be included in this conference and in this panel in particular. When Ruth Bader Ginsburg submitted what became known as the grandmother brief to the Supreme Court in Reed versus Reed, as Professor Sook mentioned, she credited two women who came before her, and one of them was pioneering African-American civil rights attorney Pauli Murray. Murray was born a little more than 2 decades before Ginsburg, and a native of Durham, North Carolina. She had been excluded from the University of North Carolina's graduate program in sociology. It was a program in race relations because of her race. And then after graduating at the top of her class from Howard Law School and leading some of the first sit-ins in Washington, D.C. during World War II, she was barred from a postgraduate fellowship at Harvard Law School in 1944 because of her sex. Having experienced the intersecting harms of Jim Crow and what she called Jane Crow, Murray made 2 really key interventions in feminist legal strategy during the 1960s while she was pursuing a doctorate in law at Yale. The first was a pivotal memorandum that she wrote while serving on the President's Commission on the Status of Women in 1962. In it, Pauli Murray invented the constitutional strategy that Ginsburg would later take to the Supreme Court. She proposed that advocates litigate for women's rights under the Equal Protection Clause of the 14th Amendment, that they use a parallel between race and sex discrimination, and that they model their campaign on the NAACP Legal Defense Fund's successful battle against racial segregation. Murray's 14th Amendment strategy had a dual purpose. On the one hand, she wanted to overcome the divisions over the ERA that Professor Sook just mentioned. And she also wanted to unite movements for racial justice and women's rights under a single constitutional banner. So that was the first intervention. 2 years later, Murray wrote another crucial memo that helped to save the amendment to Title VII of the Civil Rights Act of 1964 that prohibited discrimination based on sex. So at the time, congressional debate framed the sex discrimination amendment as critical to protecting white native-born Christian women. Murray appealed to nervous civil rights supporters who feared that the sex amendment would sink the bill. She reframed the sex amendment as crucial to protect African-American women from discrimination, arguing that without it, half of Black Americans would be left out of equal employment opportunity. Notably, Pauli Murray looked back to the fight for women's suffrage as both an inspiration and also a cautionary tale as she shaped this new feminist legal strategy. She lamented the disintegration of an alliance between abolitionists and women's rights advocates when the Reconstruction Amendments failed to include women in their ambit. Murray believed, therefore, that race and sex equality ideally should be linked in both constitutional law and in legislation in order to tie together the fates of the two causes she held dear. Long before scholars spoke of intersectionality, Murray theorized how women of color shouldered uniquely heavy burdens and provided underappreciated leadership in movements for racial justice and for women's rights. Murray hoped that Black civil rights leader Gardenia White's 1965 Equal Protection Challenge to Alabama's exclusion of Black men and all women from jury service, or Lily Willis's challenge to a similar exclusion in Mississippi, would be Women's Brown versus Board of Education. So that, of course, didn't happen. But Ruth Bader Ginsburg, Eleanor Holmes Norton, and other feminists picked up Murray's torch in the 1970s. Historian Martha Jones and Julie Sook have recently written of Black women as the vanguard of the women's suffrage movement. They played a similar, also underappreciated role in second wave feminism generally and in feminist legal strategy in particular. When Ginsburg argued that the government could not constitutionally promote a traditional male breadwinner, female homemaker division of labor in the family, she stood on the shoulders of Black feminists who had long argued that white women could benefit from emulating the more egalitarian marriages that Black couples had pioneered out of necessity. When followers of the 1965 Moynihan Report argued for restoring Black men to their proper role as heads of households, these advocates argued that women's full participation in work and politics and men's involvement in family care were integral rather than antithetical to racial progress. So this vision of egalitarian marriage and relationships between men and women mostly succeeded as a matter of the law on the books by the end of Ginsburg's litigation campaign. Think of cases like Frontiero and Weisenfeld. African American women also pioneered in other areas of the law, such as employment discrimination against pregnant women and unmarried mothers, and the development of sexual harassment law, to name just a couple of examples. Ginsburg significantly eventually achieved Murray's ambition of vanquishing the last laws that formally limited women's jury service. The Voting Rights Act of 1965 brought some of the unfulfilled promise of the 15th and 19th Amendments to fruition. Ginsburg also assisted in the effort to preserve affirmative action based on race as well as sex. In 1977, the Supreme Court issued a per curiam opinion in a case called Califano versus Webster that clearly distinguished between invidious classifications on the one hand and those classifications designed to address what the opinion called society's longstanding disparate treatment of women and to compensate for the particular economic disabilities suffered by women. It was her former student from Columbia, now Second Circuit Judge Jerry Lynch, was clerking for Justice Brennan that year. Ginsburg wrote, "If I had been assigned the task, I could not have done it better." And when Regents of the University of California versus Bakke was before the Supreme Court, Ginsburg argued that this careful distinction that she, and ultimately the Supreme Court, had drawn between harmful classifications and those designed to alleviate subordination and inequality should also apply to affirmative action and other initiatives based on race. It took longer, of course, for sex discrimination to be recognized as including discrimination based on what we would later come to call sexual orientation and gender identity. Pauli Murray, whose public persona as a woman who wrote poignantly about her mixed race heritage, masked private struggles with sexuality and gender identity through much of her early life. Though Murray did not grapple publicly with these questions, her conception of sex as largely irrelevant to a person's capacities to be a worker or citizen or caregiver, as largely was surely informed by those struggles that she had. And this conception notably resonated with LGBTQ Americans in the late 60s and early 70s. As historian Margot Kennedy has uncovered, in the early 70s, gay and lesbian and transgender workers filed sex discrimination claims with the EEOC, and those were welcomed by some EEOC officials and regional officers. But by the end of the 1970s, the EEOC and several courts had rejected these prescient claims, and activists would fight for another 4 decades before they were recognized. Other efforts championed by feminists generally, and Black feminists in particular during this period, were less successful, though. And I want to suggest that we can find in their ambitious agenda much of the unfinished business of sex equality today. So, for example, women of color led grassroots efforts to advance racial, gender, and economic justice for poor and low-income non-marital families, whose numbers grew in the second half of the 20th century. The National Welfare Rights Organization demanded the right to a minimum income that would allow women to bear and raise children outside of marriage without submitting to the employer exploitation and punitive state surveillance to which poor single mothers of color were often subjected when they worked in low-wage jobs or applied for government benefits. Others fought unsuccessfully, to extend the Social Security benefits that Ginsburg had won for men like Stephen Wiesenfeld to unmarried mothers and fathers. Advocates for reproductive rights and justice fought against coercive sterilization and for the funding of reproductive health care and a meaningful choice in whether and when to bear and raise children. Pauli Murray's vision of women of color at the center of movements for equality and justice found a lasting legacy in contemporary movements, including that for the ERA, Black Lives Matter, Me Too, Say Her Name, prison and foster care abolitionism, anti-violence, reproductive justice, and voting rights, among many others. So to close, it seems especially poignant this year as we commemorate the 150th anniversary of the 15th Amendment, as well as the centennial of the 19th and the resurgence of the ERA, that the women who Pauli Murray hoped would bring the first successful women's rights cases to the Supreme Court in 1965, Gardenia White and Lily Willis, were both voting rights organizers. Ms. Willis, who is head of her local chapter of the Mississippi Freedom Democratic Party, argued for the inclusion of Black men and all women on the jury who would hear her case when she faced charges of perjury and forgery for assisting her elderly, non-literate mother in registering to vote for the first time. The Willis family paid a high price for their activism. Lily Willis's daughter, Jenny, lost an eye when a bullet meant for her mother struck her as she stood on her own front porch in Thanksgiving of 1965. When Justice Ginsburg wrote the dissent in Shelby County versus Holder that made her the notorious RBG half a century later, she recognized this history. And she was prescient in understanding that this past, in which the freedom to vote safely or even to stand unmolested in the threshold of one's home, is far from guaranteed to women or men of color. That this past is not dead, and it's not even past. Thank you.
Thank you, Serena. And finally, turn to the other Professor Siegel. Neil, go ahead.
Thank you. Thank you so much, Judge. And it's an honor for me to join all of you this morning. I'd like to begin by thanking everyone who has spoken so far for your extraordinarily kind and thoughtful and insightful comments on my justice, Ruth Bader Ginsburg. She taught me a lot about law and about life. She taught me a lot about the importance and power of language and that it matters. Words have impact, and to really think before you use them, and to use them in a way that the listener can understand, the reader can understand. She taught me about the importance of being part of something greater than oneself, finding causes, finding people you care about and having that be part of what you do with a legal career, the importance of there being a public service or public spirited component to how one spends one's professional time. I was also moved and at times awed by her work ethic. For her, it was always about the work. She didn't care about her ego. She didn't care about her clerk's ego. She just wanted the work to be done right, get it right, and keep it tight. She would be working so hard sometimes at the end of sittings that she would be standing up just to make sure that there was no chance that she could nod off because there was just too much work to be done. She was optimistic. She was always optimistic, including in private when she didn't have to be. And I drew inspiration from that, although I can't say I'm ever going to be as optimistic as she was. And there are lots of tales about her strength and her working out. But her strength, as everyone who knew her knew well, was, right, it wasn't about exercise, and it certainly wasn't about bravado. It was about the kind of inner strength that I think few people possess, but it was real, and it got her through extraordinarily difficult times, and it also inspired everyone around her. And so during this time, which is difficult for my family and me, I draw from her strength and inspiration. And I think the last thing I want to share is that she always showed up, and she always showed up for her clerks. She always showed up for their children, for my daughters and me. Time and again, she made time she didn't have to show up, to be there, to be present. And so when a reporter asked me this week, why is it so important for you to be in DC, or why are so many clerks there, more than 100? I almost couldn't believe the question, because she always showed up for us. Right? It went without saying, without thinking, that we would show up for her. And so I don't need to tell the judges listening how important all of your relationships with law clerks are. But as John Hart Ely once wrote in another context, sometimes familiarity can breed inattention. And I have been talking to the Furman clerks and the Katzman clerks and the Rakoff clerks and your colleagues as well. And you have had wonderful, awesome impacts on your law clerks, and it really does matter in ways that are obvious and ways that may be less so. I think the most important substantive point I'd like to share with you about Justice Ginsburg, because she's been seen for a long time now, but I don't think she's always been understood. And I think it's important that she be understood both by her critics as well as those by who hold her in high regard. And Riva this morning developed this point at length. I just want to underscore it briefly, and that is that Justice Ginsburg was not an advocate of a sex-blind formal equality, as she was criticized for being during the 1980s, during an era of backlash over questions of racial equality, among other issues. She's not an advocate of sameness, as some of her admirers and former law clerks have suggested in print this week. In the VMI case that Riva talked about, she interpreted intermediate scrutiny as anti-subordination. Anti-subordination being the idea that it is wrong for government to act in ways that reflect and reinforce the inferior status of historically excluded groups, including women. That whether or not a sex classification is consistent with equal protection depends on the purposes, the effects, the dominant social meanings of the uses of those sex distinctions. That's what she's getting at in that key passage in VMI, in which she explains all the ways in which sex classifications may be used, but also the ways in which they may not be used. They may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. That is why, among other things, she viewed pregnancy discrimination as a core case of sex discrimination early in her career. The first case in which she first thought through her views about sex equality was a case called Struck against Secretary of Defense in 1972, involving a woman who was a nurse serving during the Vietnam War, and she became pregnant, and she was told by the US military that she either had to have an abortion on the base or she had to leave her military career. and abortion was not an option for her because she was a practicing Roman Catholic. And that's the case in which Justice Ginsburg, representing Captain Susan Struck, argued that pregnancy discrimination was a paradigmatic case of sex discrimination. That is not someone who believes in formal equality. She would not have seen it at all, let alone at that time in the early 70s, when the court's sex discrimination jurisprudence was still very much in its beginning stages. That's also why the justice didn't generally view disparate impact liability or affirmative action as constitutionally suspect. During her time as a lawyer, she represented men too, primarily, in my view, not for strategic reasons, which is sort of what the law tells us, but rather that she understood that freeing men from traditional gender stereotypes, freeing women from traditional gender stereotypes, which rationalized their exclusion from the franchise and public life, also required freeing men from the very same stereotypes, which rationalized their exclusion from parenting and household responsibilities. But that's not really reflecting a vision of formal sex-blind equality. It's a substantive vision. It's a vision that involves overcoming traditional sex role stereotypes, the kinds of sex role stereotypes that the 19th Amendment partially overcame, and that the women and their male allies before and after the 19th Amendment also worked hard to overcome. And as my co-panelists have suggested already, that work remains a work in progress. Let me say a few words with the time I have remaining about synthetic or joint constitutional interpretation. Riva mentioned towards the end of her remarks about the idea that the 19th Amendment could be read not just standing on its own interpretive bottom, but synthetically with the Equal Protection Clause of Section 1 of the 14th Amendment. And at first blush, when you hear such an idea, it might sound strange, novel, different, maybe even suspect. I thought we read the Constitution one clause at a time, but in fact, it is quite common. Federal courts, constitutional law scholars read parts of the Constitution in light of other parts of the Constitution with regularity. I could give you a very long list of examples, but I will not do that. I will instead give you a few examples that exemplify at least some of the reasons why we as an interpretive community in general do this, why we read parts of the Constitution in light of other parts. Sometimes it's simply to better understand the textual meanings or original meanings of words or concepts in the Constitution, given the presumption that the Constitution uses the same terms, the same concepts consistently. So you may recall that in the Heller Second Amendment case, the justices debated the meaning of the word the people, the words the people in the Second Amendment, in part in light of references to the people in other provisions of the Bill of Rights. The Constitution contains various vesting clauses. Legislative, executive, judicial power are vested. There's a presumption that what it means to vest one sort of power is going to be closely related to what it means to vest another sort of power. Think of the enforcement clauses of the Reconstruction Amendments and other amendments, including the 19th Amendment. They use language that is effectively the same. There should be a presumption that these enforcement clauses have the same basic meaning and scope, although in practice, the Supreme Court, right, has not entirely viewed them the same, although without explaining the differences between, say, Section 5 of the 14th Amendment and Section 2 of the 13th Amendment, when again, effectively they say the same thing. Or think about the famous case of McCulloch against Maryland, in which the great Chief Justice John Marshall upheld federal power to create a bank and rejected state power to tax the bank. The question was the meaning of the word necessary in the necessary and proper clause. Did it mean convenient or useful, or did it mean a necessary condition, indispensable? There is an awesome amount at stake in the answer to that question. We live in a very different constitutional regime if Maryland wins that case. And what does Marshall do? He talks about the word necessary in Article 1, Section 8 in light of the words absolutely necessary in Article 1, Section 10, which restrict state power to tax imports and exports. Clearly necessary doesn't mean the same thing as absolutely necessary. So that's one possible reason why we might look at certain parts of the Constitution in light of others. But there are others. Sometimes we want to make sure one part of the Constitution doesn't eat up another part of the Constitution. Consider, for example, the religion clauses. If all you do is protect free exercise and religious liberty, you run the risk of eviscerating the Establishment Clause, and vice versa. Think about how congressional and executive power are interpreted in separation of powers controversies. There's a concern about not allowing one to swallow up, to destroy the other. There's some search for balance. Another reason we engage in synthetic interpretation is because we want to make sure that one part of the Constitution isn't used to circumvent another part of the Constitution. When the court is in the business historically of enforcing limits on the Commerce Clause, it's much more concerned about imposing limits on the Taxing Clause. When the Commerce Clause was effectively unlimited, the court was not at all concerned about the Taxing Clause being used to circumvent the Commerce Clause. Similarly, in more recent years, the court has been concerned about invocations of the 21st Amendment to justify what would otherwise be violations of the dormant commerce principle. The dormant commerce principle, the dormant commerce clause, is clearly in the minds of the justices as they consider the meaning of the 21st Amendment and the scope of state power to regulate alcohol. And then finally, and I think this is most relevant to our discussion this morning, one reason we engage in synthetic interpretation is because we want to discern the purpose or function of one part of the Constitution, which may require looking at the purpose or function of other parts of the Constitution. We imagine the Constitution as something like a machine whose parts are supposed to work harmoniously together. So for example, in the slaughterhouse cases and Strouder against West Virginia, which invalidated racial discrimination in jury selection, the court talked about Section 1 of the 14th Amendment as a whole. This is one of a series of constitutional provisions having a common purpose, namely securing to a race recently emancipated, a race that through many generations have been held in slavery, all the civil rights that the superior race enjoy. The true spirit and meaning of the amendments, as we said in the slaughterhouse cases, cannot be understood without keeping in view the history of the times when they were adopted and the general objects they plainly sought to accomplish. There, the court is talking about not just the Equal Protection Clause, but the Due Process Clause, the Privileges or Immunities Clause. And relatedly, we engage in synthetic interpretation to update the meaning or purpose of one part of the Constitution in light of the meaning or purpose of another later added part of the Constitution. If the parts of the Constitution are supposed to operate harmoniously together, then the addition and developed understanding of a new part can affect the purposes, functions, meanings of another part. Think about how the meaning of the Fifth Amendment's Due Process Clause changes, has to change after the court eventually, almost a century after its ratification, understands the Equal Protection Clause to prohibit government-mandated racial segregation in public education. Think about how the slow but steady incorporation of the Bill of Rights, most of the provisions of the Bill of Rights into Section 1 of the 14th Amendment, transforms the Bill of Rights. We read most of the provisions of the Bill of Rights synthetically with the liberty provision of the Due Process Clause of the 14th Amendment. The 13th through 15th Amendments, as well as the 19th Amendment, arguably help legitimate the use of Congress's Section 8 powers to protect individual rights via statute. The Reconstruction Amendments, the 19th Amendment, other voting rights amendments legitimate the use of federal power to protect rights, to regulate the internal policy choices of states with respect to certain subject matters. That makes it easier, I think, for the court to decide cases like Heart of Atlanta Hotel and Katzenbach against McClung. And finally, the Equal Protection Clause in the 19th Amendment, I think, are especially good candidates for synthetic interpretation because they are linked together by history and by subject matter. The rejection of the franchise for women after Reconstruction by the Reconstruction Congress and then by the Reconstruction Supreme Court, right, provokes a half century of social movement contestation over what it means to treat women equally as the political equals of men. And the concern about women voting is that it will destroy the family. It will destroy our federal system. And the 19th Amendment goes a significant way, although by by no measure the entire way towards rejecting those claims. That restrictions on the franchise were always regulations of social status, regulations of relations within the family and within society. And so the 19th Amendment, when it is read not simply on its own, but together, synthetically, jointly with the Equal Protection Clause, I think is a way of making good, right, on what the country did when it ratified the 19th Amendment, as well as what those who fought the founding mothers that Professor Sook talks about, right, what they fought for in the decades after the 19th Amendment was ratified. And as I mentioned at the beginning of remarks, that work remains for us to carry on now that Justice Ginsburg has passed. She always understood that there were those who came before her and those who worked alongside her, that she was lucky to be famous. She was lucky to be a lawyer at a time when our country was receptive to the claim that women, women were people too, that women were protected by the Equal Protection Clause as well. And she understood that the work would continue when she was gone.
Thank you very much, Neil, and I thank all three of you for those incredibly brilliant and thought-provoking remarks. Just a reminder to folks who are joining us, if you want to click on the Q&A link and post a question, I will try to pose your questions to the panel and incorporate them into my own questions. Can't make promise that I will, depends on how many and how on topic they are, but I will certainly try. Let me start by asking a question that sort of picks up where Neil just left off, and where Professor Reva Siegel was this morning, but hopefully ties all three of you together, which is the professors Siegel have sort of painted a picture of a potentially more robust notion of the 19th Amendment, synthetic interpretation sort of tying the 19th and the 14th together. I guess now a multi-part question, but number one, is that reading still available to us, or has the ship sailed on it? Number two, if it isn't our sort of current understanding of the 19th Amendment, and I mentioned in my introduction that the 19th Amendment is not frequently invoked in the pages of the U.S. reports. When did that moment pass? Did the founding mothers, to use Julie's term, who were involved in passage of the 19th Amendment, did they sort of have that vision, a synthetic interpretation? Not that they would have called it that, but did they have a robust notion that the 19th Amendment was about more than just a decision rule about who gets to vote? It was about equality. It was about a more robust vision. Did Pauli Murray, Professor Mayeri, talked about how she was sort of the architect of modern equal protection arguments and jurisprudence on sex equality. Did she think about the 19th Amendment, or was her focus exclusively on the 14th? So I guess when did that moment pass, if indeed it has passed, and what significance does that have for us today? Why don't I start with Julie, Professor Sook, with you, and if you want to.
Great. So I think I'm very sympathetic to Neil's idea, which I think is shared by many constitutional thinkers, about the relationships between even the 13th, 14th, and 15th Amendments and the 19th Amendment, and then its relationship, the 19th Amendment's relationship to the ERA, which is also unfinished. And I think that it's clear that these amendments have had a relationship to each other. The 19th Amendment, of course, grows out of the promise of the 14th Amendment and the explicit rejection of women's inclusion in the 14th Amendment. And so I do think that it's important for us to think about, and specifically when we think of arguments around the ERA, that one of the arguments, and I think Judge Furman, you mentioned this as you introduced the panel, that one of the arguments is that perhaps an ERA is no longer needed, despite the fact that it's being revived, largely because the 14th Amendment achieved a lot of the goals of the ERA. And so that's also an example of there's ERA thinking and a constitutional movement that motors both the move towards a formal amendment as well as interpretations of the 14th Amendment. But I think there are parts of that project that are not finished. That would be in the ERA. And then, and also that there's something strange about having a partial amendment, that we recognize the principles as being embedded synthetically into the 14th Amendment, but without the ERA being given formal status. But I think it goes without saying that all of these amendments, which have been about equality and about those who were excluded from We the People at the founding in one way or another, that they bear some relationship in interpretation and historical development.
Thank you. Serena, curious to know, did Pauli Murray think of the 19th Amendment in her work in this area? Was it sort of the forgotten amendment already by that time? You know, what could have happened had history gone in a different way?
So I think that the 19th Amendment was very much on the minds of people like Pauli Murray during that period, and as well as other advocates for the ERA a little bit later in the 1970s, in a number of different senses. I think they drew from it and the suffrage movement that led to it a lot of lessons, mostly positive and inspirational lessons, but also kind of cautionary lessons about the degree to which there would be resistance to capacious interpretations that, in fact, gave women power in society beyond just the vote, which, of course, was tremendously important in and of itself. I also think that during that period and other periods as well, the idea that Julie talked about too, that people would be pursuing change under more than one amendment at the same time, or more than one strategy through litigation, legislation, multiple constitutional amendments. That was also, I think, a very concerted strategy during this period and during other periods, where drawing upon both the history of the social movements that led to the amendment and the amendments themselves is very much part of what these legal strategists are doing at a bunch of different historical moments.
Neil, anything you want to say on this score?
Yeah, I would answer your first question about is this interpretation available to us, or has the ship sailed? I would say not only is the interpretation available to us, but to a very large extent, it is already our constitutional law, right? To the extent VMI is constitutional law, and it is the seminal equal protection sex discrimination decision of the U.S. Supreme Court, then it's an interpretation that I think Justice Ginsburg suggests in the VMI case when she invokes the 19th Amendment, and she does it. She's not as explicit about it as she could be, but what's guiding her interpretation of intermediate scrutiny as anti-subordination, right, is an understanding of why letting women vote for most of our history was viewed as such a huge constitutional big deal, and what the 19th Amendment repudiated when it was ratified. Why not just let adult women vote? Because they couldn't exercise the franchise responsibly. The same reason we don't let children vote, because they depend for their subsistence on men, either their husbands or their fathers, right? Voting restrictions are regulations of social status. And what VMI is getting at is the disestablishment of those kinds of regulations of social status. That no longer is the world of educational, economic, political, public life for men only, and for family and caregiving and households for women only, right? That's the separate spheres tradition that the court's modern equal protection sex discrimination jurisprudence repudiates. And that critical orientation is coming in substantial part, right, from the pre and post ratification history of the 19th Amendment. And I think it's important to understand this, right, not simply because it's interesting historically, but because it gives critical orientation to the jurisprudence. When judges are just told, apply intermediate scrutiny, is the sex classification substantially related to an important governmental interest? Well, thank you very much, Supreme Court, right? That's not a lot of guidance, but understanding the 19th Amendment and what it accomplishes and what it rejects helps to give orientation to judges as they actually apply the doctrinal tiers of scrutiny. I think it also helps to legitimate the exercise, right? That it's not simply the race-sex analogy, right? It's not that, well, yeah, the Equal Protection Clause protects women too, even though there's no relevant constitutional history, it's simply because we're reasoning from race. And there are advantages and disadvantages to reasoning from race, but a key disadvantage is this question of legitimacy, right? Interpreting the Equal Protection Clause to include women too has greater legitimacy in our constitutional culture when interpreters understand that there is an equivalently long and significant and meaningful history associated with doing so. It's not just borrowing history from how we understand race.
Thank you. Let me ask a question that sort of jumps off from there and really presses on the kind of race-sex analogy that drove sex equality law, at least in the first instance. I think all three of you in one form or another, either more explicitly in the case of Neil or implicitly in the case of the other two, have sort of, tried to advance a reading of the VMI decision or sex equality law generally as sort of, being driven by an anti-subordination principle. I guess my question is sort of a doctrinal one, which is, do you think that that is a fair characterization of equal protection law generally, and in the race context? How do you square it with, Croson, Adoran, the sort of, modern shift in equal protection law to kind of just view race classifications generally and not really, focus on a rich historical understanding of, anti-subordination or the like? Do you think that, sex equality law and race equality law have kind of, taken different paths, even if they're based on the same amendment and the same clause? Neil, why don't we start with you?
Sure. So I would say in the area of race, the black letter law, right? Is that it's more of an anti-classification view. The idea being that the equal protection protects us against the harms of individual racial classifications, treating individuals disadvantageously based upon race. And yet you see, initially that was, I think, a sort of less provocative, less incendiary way of talking about racial harms, right? So in the 60s, Brown, in fact, is very much an anti-subordination opinion. It doesn't talk about racial classifications, although the companion case of Bowling against Sharp does, which suggests that in 54, the court was not even aware that these were potentially competing principles, mediating principles of equality. In the 60s, in cases like Loving, again, it's both anti-classification, anti-subordination, but the court seems to be moving towards an anti-classification frame because it's easier to explain that it protects all of us as individuals as opposed to certain racial groups from other racial groups. And so that's how the court's doctrine tends to go in that direction in the area of race. As the court becomes more racially conservative over time, there's more of an emphasis on anti-classification as opposed to anti-subordination, substantive equality, although to this day, it's still there in the doctrine, right? So the court talks anti-classification talk, and yet time and again has found a way to reconcile affirmative action in higher education with the Equal Protection Clause. And I think you see anti-subordination type of commitments and thinking and concerns partially animating the jurisprudence. In the area of sex, I think there's been more of an emphasis on anti-subordination, which is to say a more conservative Supreme Court has been less concerned to push back in that area, but it still has pushed back. There are cases that I think are, at least to my mind, difficult to reconcile with the VMI case. The court talks about heightened scrutiny for sex classifications and certainly never says it's not doing what VMI said it was required to do when it interprets intermediate scrutiny. But a case like Wynn against INS from 2001, certain kinds of sex classifications that the court upholds, and it seems, at least it's a question of whether it's actually applying intermediate scrutiny or declining to do so without exactly explaining why. So I think there may be more of an anti-subordination commitment today in the area of sex than race or less pushback so far, but I think in both areas, there's actually, it's a mixed bag as, as the court's ideological commitments change over time.
Instead of giving Julie or Serena the platform on that, let me pose one other question, because I know we only have about 5 minutes left and I've been warned I must end on time. All of you and Riva have sort of advocated for a rich historical understanding of the Constitution, of the 14th Amendment, the 19th Amendment, so forth. What do we do about the fact, two things. Number one, I will speak as a judge. I think judges aren't always the most sophisticated historians. We decide cases. We're not, necessarily steeped or expert in history. So what do we do about that? And what do we do about the fact that history is contested terrain? I mean, one need not look any further than, for example, the 1619 project of the New York Times and the president's recently announced 1776 commission, or whatever it was called. Or alternatively, Julie mentioned the court's decision in Adkins in 1923, which invokes the 19th Amendment as evidence that sex equality has arrived and inequality of the sexes is basically gone, and yet Justice Ginsburg, in the VMI decision 73 years later, points to that as evidence of the history of discrimination. So what do we do with the fact that history is both complicated and contested terrain in terms of how we decide these things and think about them? Julie?
So I think that is a very difficult question. And I think one place, and I don't think that judges should go it alone. That is, I think to the extent that there's interpretation of amendments to the Constitution, there's legislative history. And I think that one of the things that I've tried to do in my recent work on the ERA is to tell its long legislative history and to excavate the many voices, in some ways to make it easier for people to sift through what was said in the past. And I think that is the job of scholars and legal historians, although I think it's true that there's just an enormous pile of contested material that judges could look at. But I do think that trying to anchor it in the way in which amendments are made, and this might also be an argument for thinking about the amendment process, not just because the Constitution needs updating, which it does, but the way in which it can be done, not only through judicial interpretation, but through these moments where there's opportunities for congressional hearings and a robust way of making a pluralistic historical record that can guide interpretation. To my mind, one of the most fascinating things about the ERA revival is not just that it happened, but the floor debates that took place in Nevada, Illinois, and Virginia about history, about the 19th Amendment's legacy, about how the meaning of constitutional equality has changed since the 70s, what it means for them. The debates about the deadline extension in Congress have also brought this history in trying to think about what the ERA can mean today. And I think that these opportunities for meaning making are important. Those opportunities for meaning making often invoke history. And I think those are the moments that can guide judges in a way that's perhaps more public than just having the enormous pile of history books that you'll dive into in your copious spare time.
All right, Serena, I'll give you the last brief word before I close us out, if you want to speak to any of that.
I don't have much to add to Julie's really excellent comments. Just to say that I think it seems in recent years that historians have become more involved in directing their work toward lawyers and judges and the legal system in answering some of the constitutional and other questions that arise that in which history might be looked to. And so in some ways, I guess it's a question of whether those submissions, whether it's in an amicus brief or otherwise, are ones that are useful to courts in considering these issues and sort of focusing the inquiry so that you don't, as Julie said, have to read all the books yourself, but have a sense of how particular histories might apply in a particular case or with respect to a particular question.
Great, thank you. Unfortunately, I think we are out of time. As I said, I've been told many times I need to end this promptly at 10:35, and the clock just changed. But let me take a brief moment to say thank you to our three extraordinary panelists who have contributed plenty in this conversation and also in their writing to a deep understanding of the history. And I would encourage everybody who is listening to read their work, and much of it is included in the the program's materials, but to go beyond that as well for a deep understanding of these issues. There's much more to say. There are many more questions that I had to ask, but alas, we're out of time for this particular panel. But let me just say what a wonderful tribute to Justice Ginsburg on today's occasion. I was literally receiving texts throughout the panel about people watching the ceremonies in DC and getting those texts, thinking about the moment we're in today, and listening to all of you pay tribute to her explicitly, but also implicitly in terms of discussing the law that she played such an enormous role in shaping and was so important to her. Really an amazing way for us to pay tribute to her. So let me close on that note. I thank everybody for joining us. I thank the three panelists in particular for their time and efforts today. I thank Reva for her remarks, and I thank the bar for hosting this. Thank you very much.